Good afternoon. I'm Allie Fannin with the Greater Richmond Bar Foundation. Welcome to Consumer Auto Fraud 101. Greater Richmond Bar Foundation is a nonprofit that helps with pro bono service coordination in this area, and one of our favorite partners to do so with is Central Virginia Legal Aid Society. This program is a subset of our larger project called Triage, where we're trying to train and mobilize the private bar to better assist legal aid so that they can serve more low-income clients. And this was determined by Steve Dickinson, the Executive Director of Central Virginia Legal Aid Society, to be a critical need area that private attorneys would enjoy representing clients, that it's an interesting area and you can be trained to do it relatively well in 2 hours. So you cannot be an expert like the rest of the panel on it in 2 hours, but you can learn the basics, and they're going to give you some really great practical pointers. Today we are obviously at McGuire Woods, so we're very thankful for their hosting. They are a great partner with us as well, and I'm going to turn this podium over to Ryan. So, thank you.
Great. Well, welcome everyone. Thanks very much for attending. Today is sort of a dual purpose event. This is almost a year in the making, the official launch of the Consumer Auto Practice Group of the Triage Initiative. Neil Kessler from Troutman Sanders and I are co-chairing this group. It is sort of a virtual private practice law firm designed for the sole purpose of assisting Central Virginia Legal Aid with these types of cases. And with respect to these types of cases, it's taken us about a year to figure out what that really means. I think there's a pretty exciting range of subject matter you're going to hear about today that really caters to people from pretty broad spectrum of litigation and transactional backgrounds. So, and that's the first purpose. The second purpose is this is a CLE. This is we're going to be applying for CLE credit. There's some very valuable training materials here. And we did get everyone's email address who signed up, so we will be in touch with folks about interest in actually participating in the pro bono group that Neil and I are going to be supervising, and to be determined exactly when it's launching, but very, very soon, since, as I said, this has been a long time in the making and the need is out there. I do want to mention we have two primary presenters today, both of whom are true and genuine experts in the field. The first is John Gale, who is the founding attorney of the Consumer Law Group here in Richmond. He founded that law firm in 2001. I think a lot of people know him as the guy who wrote the book on lemon law, literally. He's a nationally known expert on consumer law who specializes in lemon law, fraudulently induced contracts, debt settlement, Fair Credit Reporting Act, and Fair Debt Collection Practice Act cases. He's authored 1988, 1990, and 1998 legislative amendments of the Motor Vehicle Warranty Enforcement Act, which is known as Virginia's Lemon Law. He's authored articles on Virginia's lemon law for numerous periodicals. He wrote a chapter on consumer statutory remedies in the Virginia Product Liability Treatise. He teaches a variety of consumer law CLE programs for Virginia CLE. He has lectured nationwide on consumer law issues. He is also someone who has appeared locally and nationally on TV and on radio, including ABC World News Tonight, on these types of issues. He is currently the chair of the Virginia Trial Lawyers Association Legislative Subcommittee on Consumer Law, and he's the immediate past chair of the Virginia State, he's the immediate past chair of the Virginia National Association of Consumer Advocates, and I'm sorry if I butchered that title. Ian Vance works with John at the Consumer Law Group. He's an associate attorney there from Lynchburg, Virginia, went to UVA undergrad, University of Richmond for law school, and while at the University of Richmond, he got involved in a wide variety of local legal aid organizations. He has worked for the Central Virginia Legal Aid Society, the Legal Aid Justice Center, and also the Virginia Poverty Law Center, practices in a variety of state and federal courts across Virginia. We also have two valuable perspectives here today. They're not going to be presenting per se, but they're going to add in their perspective as appropriate. Marty and Steve. Marty Wegbright is the Director of Litigation at Central Virginia Legal Aid Society, and Steve is the executive director and has been since 2010. I think they're going to share a practical perspective about the types of these cases that actually come into Central Virginia Legal Aid and the types of cases we could expect to handle as a group. So thank you all very much. John, are you going to be the first presenter?
Well, I was just going to take just a few minutes to talk about why I think these cases are important and why you should do them. Allie talked about why do you stand up here? It's better for me to stand in. Allie talked about the importance of pro bono and particularly the advantage we have here with forming this virtual law firm of folks to work together on some particularly important cases. And I don't think that there is one much more important to your average person than consumer auto fraud cases. And that's, I think, for three reasons. One, it's the importance to the client. There's very few things that can lift somebody out of poverty. I mean, education is certainly one, but having a vehicle and reliable use of that vehicle is incredibly important. Getting to the job, getting to health care. We do numerous polls about asking folks, what is the most pressing need you have? And almost always it comes up as transportation. And we may not think of it because we all have a reliable vehicle, but try to think of your life without one. And it suddenly, you become crippled. You become a prisoner in your own home sometimes because you can't get out. Since we all need a car or need for reliable transportation, the poor folks that buy these cars become easy targets for an industry that's preying on poor people. When I first started studying these cases, I thought to myself, this doesn't make any sense. Why would an industry that's trying to make money go after poor people? But there are billion-dollar industries out there that make their money off poor people, and mostly by treating them unfairly. And so you have an opportunity here to fix a wrong for folks that really matters to them. The second important reason, I think, is that these cases are intellectually challenging. We have a lot of subject matters that we're looking for pro bono help on, from no-fault divorces to evictions. I don't think there's one, though, that will challenge you more than an auto fraud. There are hundreds, literally hundreds of different statutes on the federal and state level that affect the sale and the warranties involving a used car. Reading them all together is exciting. It's one of my favorite practices of the law because of that. There's also things that you don't get to use in things like no-fault divorces so much, and that's math. And you can find justice in math because you can look up the contract and check the numbers and see if it balances. And a lot of times they don't. The third thing is that it's patriotic. It's good for America, right? We live in a capitalistic society. We want people to take part in the marketplace and be able to, work hard and take their well-earned earnings and go out there and live the American dream. And they can't do that if the guy on the other side of the transactions that can allow them to do that is taking advantage of them illegally. So when people walk into a car dealership with one of those big American flags on it, you expect to be treated fairly and in a open-handed way in our capitalistic society. And when they're not, they should be punished. And this is where you get an opportunity to stand up for those values. So anyway, I'm going to pass this on now to John. Oh, one other thing is that Marty and I just found out that the Virginia Supreme Court has approved voluntary reporting of CLE hours. Pro bono hours. So now this was something, I don't know if you've been following it, there was a proposal to do it mandatory, and then both mandatory and voluntary were sidelined. Voluntary has now been approved. So when you pick up one of these cases, you now have a place to brag about it to the rest of the bar that you're doing good work for low-income people. Thank you very much.
Thank you, Steve. I'll have to ask you to use your memory and go back to the introduction by Ryan. I was sitting there listening to it, and I went, wait a second, that doesn't sound like me. It's a little more impressive than the reality. And I want you to repeat that every time I call you for my wife when she tells me I'm an idiot. She's probably more accurate. But anyway, thanks for being here, and I'm happy to be here. And I say thanks for being here because those of you who are here or may be listening or listening to this on a recording, the reason to do this work, as Steve was mentioning, is not, as I may have put on my tall building lawyer suit today, but I'm in a relatively modest office at Willow Lawn in Richmond. And the reason to do this kind of work, you all, is not to make money. And Ian and I are not in this business to make money. We would like to. It'd be great if I could ride around in a fancy car and pay some bills. But the motivation behind this is hopefully the motivation that will give you all the satisfaction for doing what you do. It's not just to fulfill some firm requirement to do pro bono work. Hopefully you will recognize that when you make a difference in these people's lives, it will be huge and important to you. And it will make the work that you do far more valuable than necessarily making partner or necessarily making some money because you got the bonus this year. You were making a huge difference in people's lives, as Steve has referenced. And so I really do appreciate y'all coming in, because one of the things that happens in this business is you kind of go, well, I wonder how many more consumer lawyers are coming in, because you kind of, I'm old school, I'm worried about competition, and there is so much fraud going on out there that it's never going to stop. I mean, I used to worry, because if I start getting really successful at these fraud and lemon law cases, the car dealers are just going to start doing it right. And then I don't have to worry about it. I won't get cases, and I wonder if I'm going to practice myself out of business. Well, that clearly has not happened. Unfortunately, capitalism has a greed motive component to it, and that's why, as Steve said, it's important to pursue these cases so that these bad actors get punished either through their pocketbook or through punitive damages. And it would be fantastic if you all could help some of these people that you're going to talk to, because Ian and I, as private lawyers, do have to turn down some cases because we don't see them as possible moneymakers. These are legitimate claims. They're claims that people need help on, and we do take on pro bono cases. But there's some times that we just can't, and we'll say, well, you need to go to legal aid, or you need to go to a pro bono attorney who can really handle this, and you'll make a huge difference in these people's lives. And that's critical. We have given you 2 factual scenarios to go through, as well as some the typical paperwork that as an auto fraud lawyer you're going to get when you get somebody calling you up and saying, I've got this bad car and what do I do? The first outline here is called How to Help Your Clients' Vehicle Issues by John Gale and Ian Vance. And this is, you all, a relatively exhaustive compilation of the statutes and the case law that is applicable in an automobile claim. So it's not just fraud. We're going to be talking about breach of warranty, truth in lending, or we may not get there, Magnuson Moss, but the statutes and the common law claims that exist in these cases. And often what's going to happen when people come to you is they will have some significant problem to them that may be that their car has been repossessed and they can't get their stuff back, or my car isn't working right. Is there something I can do about it? And you say, well, fine, let me see your paperwork, and that's going to be critical. A lot of these people are not super sophisticated. They may not have their paperwork, but the paperwork can be really important, because if you know what you're doing, you can find some violations of law that they are not even remotely aware of that will be far more, that will give you the leverage necessary to at least solve their problem. it won't necessarily be something that you will make a lot of money on, or that you will take this big case. It might, but you may find some violations of law, things that can help them. For example, on a repossession case, which we're not even talking about repossessions in this scenario, but I will tell you one of the tactics that I have used when somebody comes and said, my car has been repossessed, I can't get to work, what do I do? And I go, why did it get repossessed? Did you make your payments? No, I got behind, I didn't make my payments. Well, they have a right to repossess your car. I know, but is there anything you can do? And you tell them their rights about what they're entitled to under repossession. But if you look at your contract, you will see an arbitration clause. And almost all of these dealers, not all of them, fortunately, but a lot of them do. And I say fortunately because I really don't like arbitration from a standpoint of trying to get legal fees. But in terms of helping people, the arbitration process, it's in almost all of these dealer contracts, is expensive because the arbitration clause that they have almost 90% of the time refers to using the AAA, meaning American Arbitration Association, or JAMS, or some group, and it says we will pay the initial fees because the company with that clause doesn't want there to be any defense to the clause that I can't afford this because arbitration is so expensive. They go, well, we're going to pay for all the fees. Well, all the fees is sometimes $1,500, sometimes $3,000 if they haven't registered their particular contract with that arbitration group. The point being that when you say, when the guy says they repossessed my car, you can say, well, why'd they do that? Because I didn't pay. Well, was there a problem? Yeah, they lied to me. They told me my car was never in a wreck, and it was. They told me my car was going to be in perfect mechanical condition, and the day I drove off the lot, it crapped out on me. So you go, well, let's file an arbitration claim. So you file the arbitration claim, and they call up and they go, we don't want to pay $3,000. What can we do to work it out? So there's some sort of out-of-the-box thinking like that can help these people. And that's just one that's not even in the paperwork that I gave you, but you will see in the documents there are arbitration clauses and how much they have to pay. What I'm seeing now is up to $5,000 they pay the initial fees. So let's talk about the typical situation you're going to get. And Ian is great. God, it's nice to have him associate. I never have had one for about 35 years, and I can tell Ian. Sorry, I can ask Ian to do stuff, and he put together a scenario. Can you hand me that? Now I want you all to look at this consumer law hypotheticals, because this will be a typical situation. I just wanted to point out that this outline does have a lot of information in it and case law that will help you if you have any legal challenges in your cases. But this is a typical type of, and I'll just go through the first one and we'll talk about some of the issues, and then Ian and I will decide to help you through that. So buying a car, and Jerry goes to Newman's Auto Sales that's been advertised, and his girlfriend is with him. Why would we put that in there? Because often the issue is an oral statement made to them that's not listed in the contract, and it's an express warranty, or you may call it an oral statement, that induces them to sign a contract. And it's a very important concept for you all to understand that just because the contract says as is does not mean that there's nothing you can do about it. All as is means is that you're accepting this car with its current faults, and that seller has no obligation to fix it from that point forward. It is not a shield to fraud. It is not a shield that says you can lie to me to induce me to sign this contract and then I can't do anything about it. That's what the car dealers want, or the people hope that you will not know about. But as we state in the brief, it's on the first page of the issue, we give you the cases that talk about initially what as is means and that it doesn't shield you from the fraud. The reason I bring up we have the girlfriend, Elaine was with him, because when your client says to you, well, they told me the car was never in an accident. And then you get this contract and it says as is. And what I'm seeing more and more, we didn't give you a copy of it, is some of the car dealers, especially the awful car dealers up in Fredericksburg, Stafford, Manassas area, and they're all clustered around the Fredericksburg Auto Auction. These are some really bad guys, you all. And they will put in contract after contract that says, I know the car has been in an accident. I know the car is, I've been given an opportunity to inspect it, and I'm accepting it anyway. All of that is well and good, but if they induced your client to purchase that car by a fraudulent statement, it's called fraudulent inducement, which makes the contract voidable on the part of the buyer. And so the problem, the reason we need a lane with this buyer is that we have no proof that that affirmative misrepresentation was made unless someone is there to corroborate it. And in any court action, you can be guaranteed that the seller will not admit that he lied to your client about the car or misrepresented the car when they were negotiating for it. But if your client has a witness that says, yes, they told us the car was in perfect condition and had never been in an accident, and subsequently you find out it was, then you not only have your client, but you have corroboration. And who is the judge or jury going to believe between your nice client and his girlfriend and a car dealer? They're going to believe you, and so you can feel I feel usually pretty confident that that's helpful to go forward. But anyway, so Jerry test drove the car. He then asked the salesman if anything was wrong with the car and ever had been in an accident or damaged. And the reason I put that in is that you're going to hear things in rebuttal to your claim, well, you didn't tell my client it was in an accident, and they'll go, well, or damaged. They go, well, we told him it was never been in an accident. Well, then why has the quarter panel been repaired? Oh, well, that's not an accident. That was just some minor damage. So you can see how the words that are stated are very important, and I sometimes have to pull out of my clients the words. So when you're talking to these people and you go, well, what did they tell you about the car when you're all considering buying it? Well, they told me it was a nice car. Anything else? No. I used to go, well, wait a second. That's it? Yeah, I think that's about it, Mr. Gale. So the next question should be, wait a second. You spent $20,000 on this car, and you bought it without knowing what its history was. You bought it without knowing it was in good condition. You bought it without any of this stuff. Was there no representation to you about this? And they go, oh, well, they said all that stuff. Because they don't understand how important the language is. They just don't understand how important that is. And so you got to you don't put words in your mouth, but you go, I want you to sit back and think and talk to Elaine and tell me everything they told you that made you want to part with $20,000. Because they didn't just say, there's this car over here for $20,000, do you want to buy it? You must have had some reason to think it was worth it. Oh, well, they showed me a Carfax. Does anyone here not know what Carfax is? Okay. Carfax is worth a little more than the paper it's written on. It's worth something. It does give you a history of the car. It is not foolproof. Their database is full of holes. But the car dealers have been smart enough to learn to use Carfax as a weapon of plausible deniability. So that when the Carfax is clean, which are the vehicles they purchase, the Carfax is clean. They know the car has been in an accident because they can look at it and see it, because you can detect accident damage very quickly if you're any one of these professionals. But they go, let me see the Carfax is clean, and they're perfect. I've got a clean Carfax, so whenever I'm asked about the car, I can say, hey, look, the Carfax is clean. What they do is often say, well, look, as proof of the vehicle never being in an accident, look at this clean Carfax, which is not worth that much. What we have been able to do is subpoena from Carfax a record of all the inquiries to see if there is something on the Carfax We can see who's checked it, and we can see if this dealership had it, because sometimes the dealership go, we don't have a Carfax. We never gave me, we didn't give them a Carfax because we don't have one. Well, you subpoena Carfax, which is, you may not know, is in Herndon, Virginia. And so in Virginia, we have it's not as cumbersome as getting an out-of-state subpoena. We can subpoena directly from Carfax and find out who are all the people that have ever checked out this car in Carfax and figured out if there was something on the Carfax, why it was any good. But in this case, he says, no, the Carfax is clean, and it may be totally clean. Let me tell you something else about Carfax, if that's an issue. Carfax, I'm cynical enough to think that it's done on purpose, does not report the accident information it learns about immediately. Sometimes it's months, sometimes it's years after the accident that it gets on the Carfax report. So you'll have a clean Carfax, and miraculously, after your client has bought the car, when he or she orders his Carfax, it's got an accident on it, but it wasn't there when the dealership checked out the Carfax. So I don't know whether there's something going on if Carfax is intentionally doing it, because it gets millions of dollars by having contracts with car dealerships that have access to its reports. And so it's beneficial to the dealers for Carfax to not report the car accidents that are in that vehicle so that those dealers can order it and sell those cars. Eventually that information may get on there. But anyway, let's keep going. And so Mr. Kramer said, no, it's never been in an accident. It's totally clean. He asked if it came with a warranty. And Mr. Kramer said you can buy a warranty. The car costs $10,000. The down payment is $2,000, and you get a $15,000 service contract. Let's talk about these service contracts. In one of your documents, we've got it called the ASC Vehicle Protection Plan. This document does not give you all of the information that's in, well, this may have been the cover page, but they're usually 4 or 5 pages. And what do the dealers say about the protection plan that you're getting? Oh, and you ask, well, does the car have any problems? No, but don't worry about it. We'll sell you the service contract that'll cover anything. So if you have any problem, you've got your service contract. The problem is that these service contracts exclude from responsibility any problems that exist at the time of sale. So the extended service contract is used as a carrot for the customer to not worry about any existing problems. So it's incredibly deceitful, if not a misrepresentation, for them to tell your client, you don't worry about any problems because your extended warranty will cover it. When you read the extended warranty, it doesn't cover any pre-existing problems. So if the mechanical problem or the wreck that your client is complaining about, you can prove existed at the time of sale because the transmission failed the day after he bought it or something along those lines, then you have a potential misrepresentation claim. The whole goal being to prove a misrepresentation or a concealment of a fact, a deliberate concealment of a fact that induced your client to purchase the contract, giving you the right to void that contract and to ask for the court to either cancel the deal, if not, award you punitive damages and treble damages on the Consumer Protection Act.
The papers themselves, they have a little bit of misrepresentation as well. I just sort of fly-spec these, and if you look at the retail installment contract, this one, and the vehicle protection plan, this one, verified with Ian, they are for the same transaction, the same vehicle. It's a 2004 Cadillac CTS sedan. Take a look at the retail installment contract. Midway down, description of property, odometer mileage, 138,830. Vehicle protection plan, same vehicle. In the top box, under 2004 Cadillac CTS, current mileage, 139,220. I think there's a problem there. I'm not sure what the problem is, but there's a problem there. And there may be an Odometer Act violation. Not sure why 2 papers on one dated February 25 and the other dated February 26, but it's the same vehicle. Presumably, it hasn't been driven miles and miles and miles that one day.
Right. Thank you, Marty. And Ian and Steve, if you all have anything, please jump in. Let's look at another. Now that we're flash specking these documents, pull out the buyer's order, ladies and gentlemen. So you're going, when you first time you look at these, you don't know what's wrong or right, but let me just tell you a couple things to look out for. Right halfway down the front page of the buyer's order, you'll see a box that says for as-is sales only. Everyone see that? And it's got a date and a signature line that's been redacted, but there was a signature there. Virginia has passed a statute that says you cannot sell a car as is unless on the front page of the buyer's order is an as-is clause that is signed by the buyer. What was going on was when I was actually involved in this legislation, is that people didn't know what as-is meant. So we decided, and this was not necessarily my language, but it's what we were able to get through the legislature, what it means to say as is, and people needed to know that the car is being sold as is because they were claiming they didn't know, and just because it said it up here in the middle of it, they signed it down here. So now they've got to sign it. But if this language is not on the buyer's order and not signed by the client, I don't care how many as is separate documents they sign, it's not being sold as is, and you have the implied warranties potentially under the statute.
Let me just add to that. Under the statute, if that's not separately signed and dated, you've got 30 days to cancel the contract. If that's
Right.
what the client
Thank you.
wants.
That's right.
And just so the folks know, the buyer's order is the contract to buy the car. Okay, there's usually two basic documents you get with every car sales. The buyer's order, which almost all the language is required by Virginia law, and it's in a statute that you can look up and just compare the two. And then the second document is the retail installment contract, which is the loan you take out to buy the car. And you have to read these two contracts together, but they're two separate documents with two separate sets of rules, or different sets of rules that determine what's in each one of them.
And just because there's a buyer's guide, this one, that's required by federal law, does not mean that the dealer has complied with the buyer's order, which is state law.
Right.
Both are required, and both have to be proper.
Don't be confused. If you look at this buyer's order and this, we call it a RISC, retail installment sales contract. If this, or credit contract, they are not of the same car, because what would happen is the amount, the total, this one actually, this buyer's order must be is for a cash sale, because there is no balance due. Usually on the buyer's order where it says balance due at the bottom, there might have been some down payment. And let's look at the retail installment sales contract. You will see this, it's these Regulation Z of the Truth in Lending Act required these boxes to make it clear what people were buying, and so that they understood. In this case, you have the annual percentage rate, which is 24.99. The finance charge is the amount that the credit is costing them. The amount financed is the amount of money that they're borrowing, which would be the balance due on the buyer's order. The next box, total of payments, is of course the number number of payments that you will have to make. And then the final box, total sales price, gives you, including your down payment, the total cost of this vehicle to you over the life of the loan. So on this particular retail installment sales contract, the balance due on the buyer's order would have been $5,241.26. The interest being paid on that was $2337.82. And I'd like, well, it's been blanked out. Well, I'm not going to go into that. So anyway, those are some of the things. Let's keep going on this factual scenario. So when they come in, just the different issues that come up. So in this scenario, Mr. Jerry paid down $2,000 in cash. He paid $1,500 for that service contract. If you're curious about the profit in these, if you paid $1,500 for the service contract, depending on the vendor, you're probably looking at maybe $250 cost to the dealer. Sometimes if it's a better service contract, it might be $500, but you'll see them for sale from $1,500 up to $3,000 for service contracts that are costing the dealer $500, $600, and all of that is profit. So next time you go buy a car, you can maybe get a cheaper price than what they're offering because you know what the cost is.
And I'm sorry, John, real quick on the service contract, two things is, one, your client is not going to say, hey, I bought this service contract.
Right.
This is an individual who's going to say, I bought a warranty. I was given a warranty. So you've got to, before you meet with your client, I guess it's more of a practical point, and Marty can talk about it. And in my experience with legal aid, it's best to get all of these documents up front. See what's actually written, see what's disclosed to them, what the numbers are, then meet with them and talk with them because they're telling you, I got a warranty, they're not honoring the warranty, you've got your breach of warranty, Magnuson-Moss warranty hat on. But in fact, you actually got a service contract. They told you it was warranty, but it actually was a service contract. So get all the documents beforehand, review them, then meet with the client so you can find out exactly what was told because if they tell you this is a warranty, that's another potential misrepresentation for violation of the Virginia Consumer Protection Act. If they say, don't worry about it, this thing's going to cover everything. This is a warranty, you're good, just call this company when you need help or whatever. You drive off the lot, check engine light comes on or something, you think you've got a warranty, you call the dealership, they go, sorry, that's not a warranty, we're done with this, you got to call this company. So make sure when you meet with the client, what was told to you, I was told warranty, but actually you're given a service contract, you're sold a service contract. And the second part is sometimes these dealerships, and in my experience, if a dealership spells car with a K in their name, probably they did something wrong. So just get your ears ready, tuned up that there's some misrepresentation. They may induce the buyer to say, hey, we can get you better financing at a lower rate if you buy the service contract. That is not required for financing, but they'll tell you that. Same with gap insurance. Oh, if you buy gap insurance for $800, we can get you better terms on financing. That's not required. That's a misrepresentation.
So, if I may ask a question,
Yeah.
it says on the service agreement, the name is AS31, so is that just a misleading name of the person that's providing the service?
Yeah, that is definitely, but they're going to come back and say, well, it actually right there says service agreement. Though our name is something warranty company, they're not really warranty. It's not a warranty with the dealership at least. And just how John said Carfaxes are worth a little more than what they're putting on, service contracts, in my opinion, are worth less than what they're putting on. Because this is page 1 of 1, so this service contract is 1 page, but a lot of times buyers will get 4 pages and it will just talk about what they exclude. They exclude everything. They basically don't cover anything. So you paid $800 to $3,000 for something that you're never going to be able to get the benefit from.
Well, then you're going to get into what's the definition of a warranty and what's the definition of a service agreement under, and who's defining it. And you've got different statutes that define that those terms differently. So for the
some of those companies offer both warranties and services.
no. Well,
He didn't even know that service provided. Corporation in Florida.
Well, it's all sold under misrepresentation. So it's, the whole idea is, and from you all's standpoint, the question for these people is, can I get out of this deal? Can I just get out of it? I don't need to, I'm not buying my Porsche, Mr. Gale or Mr. Vance, off of the winnings here. I just want to get on with my life and get out of the deal. And sometimes the squeaky wheel gets the grease, and maybe your all squeaks can be louder than the clients. And a letter to them, and the idea that McGuire Woods or Troutman Sanders or one of your big firms are behind this might, what I generally find is that with the smaller dealers, they're very rarely saying, we'll see you in court. They just want to get out. They don't want to have to pay a lawyer a bunch of money unless they're really pissed off or something. And so they'll try to get out. But we've taken the case on because we want the client to get more than just get out. And we also, unlike you all, we need to get paid our legal fees. So you all may be able to help these people in a far better way if they see that you all are behind these clients and that you will go to bat for them, that you will go to that general district court hearing or that circuit court hearing, because, you're not there to try to make money. You're there to help these people. And that's going to be powerful, because if I'm that dealer's lawyer, I'm saying, look, every car dealer, because we've given talks to the Automobile Dealers Association, and it's a room full of car dealers, and I'm telling the same stuff I'm telling you. And I tell them, you all are idiots to fight me or us in court. We're coming in the white hat, you're coming with the black hat, and unless the lawyer who's fighting you is an idiot and has taken on a really bad case, or the client is a convicted felon, the consumer is a convicted felon, settle these cases and get on with your life. You don't need the publicity. You don't need the word getting it. You don't need 12 on your side doing a report. And settle these cases before it gets to me or Mr. Vance. Or settle them, and you all are in a position that your clients may not be out for blood. They just want to get on with their life. And I think that could be very powerful. You all are in almost a better position than Ian and I are, because we've got to recover some money for this some of the time. We're happy when we can get it worked out, and if we don't get paid. But most of the time we're trying to, at least we're going to the guy and saying, get them out of the deal and pay us our 3 hours or our 4 hours in the case. And they go, screw you, we'll see you in court. And we go, okay. So,
in that same vein, as John said, sometimes a demand letter will do a lot. You've got that Esquire at the end of your name. That's going to scare a lot of these guys, a lot of these used car dealerships. But then, in my experience, it's kind of a 50-50 split. You're going to get these dealerships, cool cars with KK in it, where they say, you know what, we didn't do anything wrong. We've been doing this for so long. Your client is in the wrong or something. And shady used car dealerships may hire not the best attorneys. They're going to find an attorney that helped them with their own criminal issues. And so keep in mind that it's not always going to be my demand letter gets this thing settled, we're done with it. You might be in this for the long haul. And not to scare you away, this might entice you to say, oh yeah, we get to do all these motion practices and go through court and trial, because this criminal defense attorney who now is trying to do auto fraud defense is going to make your life a little difficult, because they're going to bring up things that totally make no sense at all. So just be prepared for that.
I didn't mean to. Let me just say one thing in response to Ian. I did not mean to leave the impression that a demand letter is going to help a lot. My experience has been it does not. My experience has been that the only time they get serious is when I filed the warrant in debt or I filed the complaint. A lot of times they don't even read the demand letter. You can try it. It doesn't hurt to send the demand letter. But most of these guys are not sophisticated enough to go, I better settle this, or they'll call up and they'll go, well, we'll work something out. It doesn't hurt, but from a efficiency standpoint, for me in my practice, I've just said, screw it, we're filing suit immediately, because they'll know I'm serious. They'll know I'm not bluffing. And then they'll call and they'll go, let's try to figure this out. So anyway, I'm sorry.
A question for a smidgen of context here. Some of the bigger firms in Richmond, Woods included, represent some of the larger car dealerships as clients. So that people don't think conflicts are going to be too big of an issue here. Steve and Marty, the types of cases that you guys get that you would anticipate referring to our group, can you Clarify, are the majority of those that concern car sales small kind of used car lot type places as opposed to the bigger, more reputable dealerships?
Yeah, but for the most part, I mean, occasionally I'll get in, somebody goes to a Ford dealership and it's Ford Motor Credit Company that's behind it. Almost all of those I've resolved with a phone call out. It's the small dealerships who are either self-financing or they're farming it out to places you've never heard of that are the ones that we have.
Yeah, typically they're not dealers that sell both new cars and used cars. You know, they're licensed Ford Motor or Chrysler or whatever dealership. They are the dealerships that sell almost exclusively the used cars. And we're not talking about the big used car dealerships like CarMax. We're talking about the really small firm.
And those types of dealerships are probably less likely to cause conflicts for the bigger firms in town.
Right.
Yeah, it's pretty rare. You know, I had a case come in recently, blatant fraud. Judge Marriage told me a long time ago after a opening argument, he said it in front of a jury. I did opening argument, and then he goes, "Mr. Cale, that was an excellent opening argument." I said, "I cannot believe this federal judge in front of a jury has just told me I had an incredible opening argument." And so I was puffed out, and then he looked at the jury and goes, "But ladies and gentlemen, I heard something a long time ago. Every pancake has got two sides." So it was perfect, because then the defense attorney felt relieved, and he could come up and give the other side of the pancake. But I will say that Marty and Steve and Ann are right. Most of them are the small-time dealers, but I did get in, and so I've heard the story. But I've got not a Richmond dealership, but where is Stroh Snyder? Anyway, I think it's maybe in the Williamsburg area. I've got a rather large dealership. There is the exception that, and I have a feeling Kaufman and Knowles is going to be defending this one, but there's an occasional we'll have a big one. Which is they'll be smart and try to settle this thing quickly. And just sort of, if you're curious, I've already told my client, do you want to get out of this thing or are you ready to go to the mat? And some of them are so outraged they were ready to go to the mat until they found out what the cost of the litigation is going to be. Let's keep going on this scenario or hypothetical. So Mr. Kramer and Jerry and Elaine shake hands and they buy the car after signing the buyer's order, the buyer's guide, and odometer disclosure and the credit contract, which we're calling the risk. Right after purchasing the car, the check engine light comes on and starts shaking violently, and Jerry has to pull over and he has to go to his friendly mechanic, Mr. Costa, and he says the radiator's been bypassed so the transmission's not getting any coolant. The hoses were intentionally rerouted. The car needs an entire new transmission, and that's going to cost you $6,000. And he thinks the car shows prior accident damage. So what do you think the as-is clause has? Does that as-is clause, is that any defense to Mr. Kramer, for Mr. Kramer, you all? Do you think the as-is clause shields him from this claim of the transmission being bypassed?
It's certainly going to raise it as a shield.
Well, the answer is no. Look on the first page of the outline where we talk about what as is means, and look on section 1A2, and I've given you all two cases that specifically hold, Packard Norfolk and Roberect, which specifically hold that as is sale in the contract, if it's induced by fraud, makes the contract voidable. So anyway, we wanted you all to be aware of that important fundamental issue. So Jerry calls the dealer and speaks to Mr. Newman and says, "Hey, the transmission's bad and I think I've got accident damage." And Newman says, "You bought it as is." He calls the service contract company and they say Newman never completed the paperwork, so that's rejected. And Newman refuses to do anything for him, and the dealership says, doesn't respond to his calls. So that's a typical scenario, and I think you've got a case here for a fraudulently induced contract. The as-is clause is irrelevant because all that clause was for protecting any future repairs. It doesn't mean he could lie to the customer to induce him to sign the as-is contract. I mean, think about that. You ask, does the car have any problems? No. The car does not have any problems. It's a great car. It's in great condition. Now sign this contract as is. These people believe the salesman or the salesperson. And so that's a fraudulent statement, and they would never have bought that car as is if they had thought there was something wrong with it. But the person that they trust, the salesman, has told them the car is in perfect condition and doesn't have any problems. And believe it or not, these people believe them. I think the only profession that's lower than the lawyers in the public's perception are car dealers. And I'm kind of not kidding about that. And but the car dealers, but surprisingly, and what I've gathered over the many years I've been doing this, is that people trust other people because they have not been screwed in their life. They've not been shafted a lot, and they're nice people, and things have gone good in their life, and so they just believe people are going to be honest. So they believe people when they say the car's never been in an accident or is in good condition.
I get a lot of folks too that come in and say, I believed him because I met him at church, or he was recommended by my pastor, or he's my cousin. And then, and they still get shafted about it.
Well, the best for me was when they came in and the husband and wife said, oh, and he was bringing up Jesus during the sales call. He says, I'm a Jesus follower, and we knew we could trust him. And I thought, oh, my God, if a jury hears this, they are going to draw and quarter this person. And that case settles.
That's JD, right?
Well, let's talk about the second
I'm sorry, John, before we get to that, just to finish up the first one.
Sure.
As John said, this seems like a good case, misrepresentation and fraud, because it says that this was a rigged transmission. This wasn't just, hey, this is an old 8-year-old Toyota Corolla, things are going to happen when you drive it for 150,000 miles. Somebody went in there and bypassed this transmission. So to tee this case up for a good fraud, Virginia Consumer Protection Act case, you're going to maybe have to enlist some experts. You're going to have to maybe get that mechanic, Mr. Costanza, to come to court and testify and say, hey, in my 20 years of experience, it obviously takes somebody to do this. This wasn't just an accident. These hoses just don't accidentally fall apart and then come back together this way. This was intentional. And so you've got to ask your client, who looked at your car? Because a lot of these legal aid folks get the neighborhood car guy to look at it, right? And so he might not be reputable, and he might not be good in front of a jury or come trial time. So you want to ask your client, who looked at it, who's the mechanic, can you take it to somebody else, a more reputable mechanic, so that they can come to court and testify and say, in their experience, they've looked at cars like this has obviously been bypassed. Same with an appraiser. So when you're determining damages for the value of this case and what to get your client, one of your damages is diminished value. This 2010 Toyota Corolla was not worth $10,000. Because of this rigged $6,000 transmission problem, it actually was only worth $2,000. So I have diminished value of $8,000 plus whatever financing on top of that. So you're going to have to get an appraiser, somebody look at and say, yep, I can determine that this was only worth $2,000 on the date of sale or whatever for damages. So just keep that in mind when you're talking to these clients, that you want to make sure that they are kind of doing their checklist and that they're doing their homework to make sure that you can tee this case up to get as much recovery as you can for your client.
That brings up some pre-litigation investigation, and I don't know how much you all are going to want to do. It's critical to do this in order to, if your attempt is to get punitive damages or as much leverage as possible over this fraudulent seller, you need to prove that his misrepresentation or her misrepresentation was intentional. Now, Virginia does permit claims for intentional and unintentional misrepresentations, and we call it actual fraud or constructive fraud. The remedy for actual fraud, meaning intentional misrepresentation, are your damages and punitive damages, possibly legal fees for a common law fraud claim. For constructive fraud or unintentional misrepresentation, suppose the car dealer, when you write them or call them or talk to them, they go, we didn't know. We didn't know it was wrecked. We didn't know the transmission was bypassed. We just got it from Susie Smith and she traded it in and it looked like a nice car and we put it on our lot and sold it. So that the 100% of the time almost, unless you've got them by the short hairs, is we didn't know. So your job, or our job often, is to prove that they did know. And how do you do that? And it's not super easy. You got to look into the history of the car. And there are things that you can do. For example, you can write DMV. And if any of you all let me know, I can give you a copy of a letter that we write to DMV, and they will give you a title history of that car. And you will be able to see who the prior owners were of that car as long as it was in Virginia. Now, if the dealer bought the car at an auction and it came from New York, every state has got a process to find out the title history. But you can find out the title history often from any of the states, and the one at DMV here in Richmond will give it to you. DMV will send you a copy of all the titles, and if it's a car dealer, you can see it, any prior dealer. If it's a private person, that DMV history will be redacted for privacy purposes, but between you and me, and y'all don't tell anybody else. It's kind of like Obama's speech the other day. He didn't want anybody to know, but of course we all know what he said. DMV redacts these titles, which you might have 4 or 5 of them, with a magic marker so that the private person's information isn't produced, and you look through the magic marker and there it is. So you put it up to a light and you can see it. Sometimes it doesn't. It's not 100% that way. For me, it's about 60% of the time that the person at DMV has just used a magic marker and marked the name of the individual. The point being, you then write that person or call them if you can get their contact information. Go, hey, I'm representing Miss So-and-so, and we would like to know, when you traded this car into Newman's Auto Sales, did they know about the transmission issue? Oh yeah, the transmission was terrible. It wasn't working when I traded it in. Or the car was wrecked. That's why I only got $3,000 for it, that they turned around and sold for $10,000. So that's how you can prove, by going through the title history and then finding a prior owner. Of course, I've done something even a little more not dramatic, but different, is that when my DMV search doesn't produce it, I will file a lawsuit and not get the lawsuit and not have it served. File the warrant in debt, or you file your complaint. You ask the clerk, don't serve it, but you do then now have the ability to send out a subpoena to DMV, and it will not be redacted, or a subpoena to the auction if you know where it came from, or a subpoena to New York or California or North Carolina where the car came from, and you get all this information. And then you can decide whether you want to take the case or not. And if you get that information, you then write the prior owner a nice letter saying, I'm sure you disclosed this information, because if you didn't, there may be some liability on your part. But as long as the dealership that you sold it to knew that the car was wrecked or that the transmission didn't work, you have no issue. And would you please call me? And 60% of the time, I'll get a call back from people who are just nice as they can be. Oh, no, they didn't know, or I didn't think it would. But at least you get information and can decide. And then you have some serious leverage over these people, because they're facing not only the damages for fraud, which is the different. And under fraud, there are 2 remedies that are mutually exclusive. One remedy is actual damages, which is the diminished value, meaning the value of that vehicle on the date of sale, not on the day that they come to you. On the date of sale, what was that vehicle really worth if the truth were known about its history, about bypass transmission or the wreck or whatever? You paid $20 for it thinking it was not in good condition. Thinking it was in great shape, no problem. in fact, if it were truthfully disclosed that the vehicle had a bad transmission and had been a prior wreck, what was its value? That's why what Ian was talking about, you need an appraiser. An appraiser will look at it and go, well, that car was worth $10,000. It was worth something. Your client will go, I wouldn't have bought it, but it was worth something. Let's say it was worth $10,000, so your damages are $10,000. They keep the car. You get $10,000. And so those are the damages for actual fraud or constructive fraud. With actual fraud, you also get access to potentially punitive damages for punishing them for lying to your client, which can be from $1 up to $350,000. So there is some real leverage there. Under the Virginia Consumer Protection Act, if you prove this kind of fraud and actual misrepresentation, you get up to treble actual damages and legal fees. And under the Virginia Consumer Protection Act, if the misrepresentation or the concealment or the false promise or the deceit was unintentional, you get your actual damages. They call it restitution. That's 59.1-207. There's the unintentional section of the VCPA. And you get legal fees for unintentional misrepresentation. It's discretionary, meaning the court or fact finder may decide they want to give it to you, but you can make a claim for legal fees under the VCPA for an unintentional misrepresentation. And I've almost always gotten them if you can show some sort of deception or something that doesn't smell right on the part of the dealer, and usually they'll settle those. So anyway, that's so other things that you can do to prove prior that they didn't understand. Did the dealer know? Is you got to find the prior owner and contact them. Sometimes the wreck damage is your dealer will go, I didn't know, and your client will say, well, there's something wrong with this car, so we'll send it to a body shop, have the body shop look at it and go, oh my God, this is awful, and they'll take these pictures, and if it's really obvious wreck damage that no one could possibly miss, who's a professional, you have to put your lawyer hat on and go, would a jury buy this? Would a jury buy that there's no way you can miss this? And if it's pretty obvious, I take those cases. And you can take those cases. And because you're not worrying about getting paid, and the dealership, if it's really obvious wreck damage, it's a very fun deposition to take the deposition of the person that bought these previously wrecked cars and ask them, you didn't notice this, and you show them a series of pictures that are just awful. And you missed this? Oh, I didn't see that. I'm human. And you missed it? Oh, I didn't see that. How long? And, if you lay the groundwork, how long was your inspection? 5 minutes. I don't get a lot of time, Mr. Gale, at these auctions to inspect these things. They have all the time in the world they want. They just choose to take 5 minutes, if that. So anyway, those are some ways that the obviousness of the wreck damage and the prior owner history is a way to find out this information.
And some other pre-litigation investigations you can do is reach out to the inspection station. And a lot of times, these dealerships are going to say, hey, we got it inspected at Joe's gas station. He gave us the green light, said it was good to go. We didn't do anything about it. We didn't look at it at all. So you can contact the Virginia State Police, do a photo request for a couple dollars, find out who the inspection station was, reach out to them. They're going to cover their own behind. They're like, oh no, we totally told them that the brakes were rusted and the whole rear end was rebuilt or something, whatever. So that's more information and leverage you can use when it comes to, hey, my client just wants out of this, wants a quick recovery. More leverage when it comes to demand letter time. Hey, I talked to Joe's gas station. He said that you actually knew about XYZ. Therefore, this case is worth X dollars. Why don't we just settle now? So some more leverage you can have. And then also, even if it's a so-so case where, as John said, just doesn't seem right. The damage is there. Something doesn't seem right. It's as is. You can take these cases in general district court. This is a GDC judge who sees all different types of cases. And with you having no financial stake in it, not saying, hey, I can't give up 20 hours of my time because I've got to get paid. You can go through it all through GDC. It's a court not a record. You can try it out. And you can try to appeal to this judge who is a person just like us who sees used car dealers all the time and understands the reputation they have, and you might be able to show that this is enough information here to show that they knew something was wrong with it. Maybe it wasn't intentional, but obviously something was wrong with it. We're going to award some damages for the car.
And you draw an unfortunate general district court judge, don't despair. Because if you've got a legal aid client, you have a free appeal to circuit court. There's a specific statute that allows for a waiver of appeal bonds and the circuit court writ tax and costs for indigents. And indigent basically means you're at or below 150% of poverty. And those are our clients, because they're at or below 125% of poverty. There's a court form that's available that you can fill out and have ready to go into general district court at your trial. And if you lose, you can immediately ask the judge to waive the appeal bond and writ tax and costs and take it up to circuit court and do it all over again with a jury and discovery.
You all, if you would look at page 2 of this of the fraud outline called "How to Help Your Clients' Vehicle Issues," I wanted to point out at the bottom of page 2 potential defendants, so that you have some leverage. It's not always just the seller. Suppose your investigation reveals that you cannot prove that the dealer knew it, but you can prove that the person that sold it to the dealer knew it was a wrecked damage and didn't tell the dealer. That's a remote seller. There is no requirement in Virginia on a claim based on fraud or a misrepresentation that there be privity of contract. And most defense lawyers that I run into will immediately start yelling at, well, we didn't know. We didn't even know who this person was. We don't have any contract with them. We don't have any obligation or reliability to him. Yes, you do. And if you look at the statute and the cases that I've cited for you on page 2 and 3, Virginia has held that privity of contract is not a requirement if a representation was made that was reasonably known to have been passed on to the ultimate victim in the scenario. And so it will be a fight. I'm just letting you know that don't be necessarily disheartened because the immediate seller doesn't have it, but you can tell that the person further up that chain did know and did commit fraud. Then they have potential liability. And also, don't forget the person that made the misrepresentation, him or herself, is liable. So in your lawsuit, you would bring it not just against the dealer, but you would bring it against the salesman for lying, and you would bring it against the owner of the dealership if you have any basis to state that that owner had some knowledge of this and instituted the policies or participated or approved or sanctioned the fraudulent practices. So they are a potential person to bring a lawsuit as well. Let's go on to page 4 before I forget something. And I talked a little bit about prior collision damage and getting an expert or a body shop. But look at the top of page 4, small Roman numeral 4, it says the 3% rule. That's a mistake. It should read as follows. A Virginia statute allows dealers to not disclose pre-sale damage to cars such as shipping damage if the cost of repair does not exceed 3%. So in other words, I could have said it a lot easier. If the damage doesn't exceed 3% of the value of the car, then they don't have to disclose it on a new car. So if you're going to buy a new Mercedes, it costs $100,000, and there's $2,000 worth of damage that's been done to it, valued at what I mean by retail. The retail cost of that repair was under $3,000 for your new Mercedes or Porsche or Jaguar or Land Rover. They don't have to tell you about it. If you find out about it later on, I think they're going to work something out with you, because it's pretty outrageous. But just so you know, that rule is there. It used to be 6%. and we were able through the legislature to get that changed from 6 to 3, but it's still there, and people are shocked when I tell them that the dealer didn't have to tell them about it. And one other urban myth that a lot of people believe, and over years I think I've figured out where it came from. You know, on real estate transactions, you have 3 days to to cancel the refinance. So there's this 3-day period that lawyers sort of know about when you're refinancing or getting a loan that you can decide not to go through with the deal. People, for some reason, think there's a 3-day right to cancel when they buy cars. We probably get once a week or so. People going, well, I tried to cancel this deal within 3 days and they wouldn't do it. There's no right to do that. It may be in a contract with a dealer. The dealership may have some policy individually. We will take any car back within 30 days if you don't like it, but that's not a state law. I had a case come in just the other day where the contract, there was a 5-day right to cancel. The contract was dated Wednesday. On Saturday, the day they delivered him the car, he takes it home. He sees it's got all these issues. And on Monday, within what he thought the 5 days, he canceled the contract. They said, no, it's not 5 days, because the 5 days began to run from the date of the contract, not the date of delivery. So it's just, and they're going to, I just want you to know that's just sort of an interesting claim. Let's go on to page, a couple of more legal issues that you need to know about we might miss. Go to page 5 of the outline, and it talks about applicable statutes and warranties. And the only thing I want to tell you about you can read this, and there's really good information, fascinating. I'm sure you'll be up all night reading it. But under the Virginia Consumer Protection Act, there's been a significant change that the Supreme Court has done for consumers. Since its inception, the Virginia Consumer Protection Act has unfortunately been interpreted by the courts as being sort of a codified common law statute, and consequently the burden of proof and all the laws that applied to common law were being applied to the Virginia Consumer Protection Act. The Virginia Supreme Court recognized that in enacting the VCPA, that the legislature was trying to expand the remedies for people who were victims of fraud, and consequently they changed the Consumer Protection Act in 2 significant ways. One is that standard obligation to state with particularity the fraud that was committed in your complaint. While that is true with common law still, the Consumer Protection Act has been interpreted not to require stating the fraud with particularity in your bill of particulars or your complaint. And more importantly, the burden of proof under fraud, as you may or may not know, is we've got preponderance of the evidence, you've got clear and convincing evidence, and for criminal violations, you've got beyond a reasonable doubt. Fraud has got to be proven by clear and convincing evidence. Under the Consumer Protection Act, it's by the preponderance of the evidence by way of the new case under Virginia, which is, I think it's called BLLAGH, which is on page 6, where the proof must be by a preponderance of the evidence. It's a 2015 case. And that's pretty important. Lawyers seem to think that that burden is really a big deal. Personally, when I've been in court and arguing for a jury, I almost never argue burden of proof. You just tell them the facts, and juries don't understand, in my opinion, a whole lot of difference between preponderance and clear and convincing. You just argue it, and if it's you give them your sincerity and your facts, and hopefully they'll understand it and follow you. But a lot of lawyers think that's important, and I do think in settling these cases with a lawyer for a car dealer or a seller or whoever is committing the fraud in your case, that's something that's appealing and as a piece of leverage. Why don't we move on to, because we only got about 40 more minutes, let's talk about negligent repair, warranty, and service contracts, which we've kind of touched on. But this will be another area of law, potential cause of action that you all will come across. And people will come to you and go, well, I bought this car and I got a warranty with it and it's been having these problems. What did they tell you about the car? Well, they told me it was a good car. And let me mention this. A good car, is that a fraudulent misrepresentation if it goes bad the next day? It's a good car. How about it's a perfect car? Maybe better. How about an excellent car? The Supreme Court has found that an excellent car is not puffery or an opinion, but an excellent car is actionable. That's fraud. The Supreme Court of Virginia, both the Supreme Court of Virginia, has found that, perfect car was actionable. Excellent car was just what we call puffery. And I think there's some common sense to this. When we go buy a vehicle, we expect what we call sales talk. She's a beauty. She's a little old lady that may be actionable. A little old lady used it to get groceries. But we all expect that kind of puffery. But so I do want you all to think about that. You need to ask, did they say anything to you that strikes you if you were the judge? Would you go, well, that's just not right? Or I expect sales talk. And I think we can use our common sense to decide whether something is a misrepresentation of a fact, or is that just an opinion and mere sales talk, which we in legal circles call puffery. So that brings up the issue. Suppose it's just puffery in your opinion, but your lady that's in front of you has got a car that's just not working, and she took it in and she tried to get it fixed and they screwed it up. Well, what's the cause of action there? It's no different than a malpractice case against a lawyer or a malpractice case against a doctor. It's just a malpractice case against this repair shop called negligence. The beauty that you all are going to be, this thing that you all are doing that's so helpful is that when a negligence claim comes into Ian or myself and they go, well, there's really no fraud here. When they fixed my car, they totally screwed it up. And they gave me a new transmission that's cost me $3,000. And now that's bad. And I got to put it, they're telling me it's going to cost me another $3,000. Well, there's no fraud there. It's just, was there a negligent installation or was the product bad and something they did wrong in ordering it? And so you simply have a negligence claim, and your damages for a negligence claim is what is it going to cost? What are your client's damages as a result of this? Now, that's not just the cost of repair. It could be the fact that there may be some consequential damages. There may be some incidental damages, like they had to borrow another car to get to work. They had to take the children to school, whatever. Negligence, just like any negligence claim, whatever your damages are, there's no contractual disclaimer that's going to apply to all these contracts we exclude incidental and consequential damages. Well, that doesn't apply in a negligence claim because we're not suing under the contract. Don't forget, if you're suing under the Virginia Consumer Protection Act, that's a statutory claim. It's just statutory. You're not suing under the contract so all of those disclaimers have nothing to do with it, are irrelevant. So if a lawyer for one of these defendants tells you, well, we've disclaimed consequential damages, you don't get that. Well, it doesn't matter. You're suing under the Virginia Consumer Protection Act, or you're suing for negligence, and the contractual defenses are not applicable. But we have here a negligent repair. And so what do? Well, you need to know what the cost is. And most importantly, what do you need when somebody's suing your doctor and you're defending? They have a doctor saying he screwed up under the standard of care in this area. And the same thing is true with a negligent repair. You just need another mechanic to say, yeah, he screwed that up. You may have to pay them to come to court. But your goal would be when your client says, well, they screwed this car up and now it's bad. I say, do you have any mechanic telling you that they screwed up when they installed the transmission or that they did this thing wrong? Well, no, they have to go get that. I mean, I guess you could try to make a claim against the dealer without that. but it makes your case far more leverage if you have another mechanic or expert saying that what the dealership did was negligent, and then you need somebody to also tell you what it's going to cost to make it right. Ian, why don't you did this? You also did this. Why don't you go through this? What else is going on in here? Jerry.
This involves the service contract.
Yeah.
So Jerry takes his car to Costanza. Costanza is going to tell him it's going to be $6,000 to fix. So Jerry calls his service contract company, J. Peterman Protection. J. Peterman says, first you need to pay $150 for a diagnostic. That's pretty common. You call this, for example, what is that? Service contract, ASC warranty. You got to call them before you do anything. And they're going to say, well, first you got to break it down, and that costs you $150, $200, $300. Figure out what the problem is, and then this company's going to come back and say, oh yeah, that was all pre-existing. And they basically blanket. They always do because they don't want to cover. They're in the business of not providing coverage. So you've got to look through this contract, through this service contract, the 3 to 4 pages that come with it, to see if you can find a way that, hold on, this rerouted transmission or whatever, this coolant issue is actually something that's covered. And they should cover it because it says here right under whatever paragraph in that service contract, they have to cover it. In this hypothetical, it then goes on that Jerry can't get the coverage from the service contract, so he pays the $6,000 out of pocket. Costanza keeps pushing it back, taking him a month or so longer. And so once repairs are completed, Jerry picks up the car, takes it down to the beach with his family, short round trip, comes back. On his way back, now he's having all these problems overheating, and then he takes it to a nearby mechanic, Putty's, and they determine that the wrong valve was used to repair it and the correct parts were used. So basically, as John was saying, it's a battle of the experts or such. You've got this mechanic, Putty, saying, actually, you did this wrong, you were supposed to put in this part, and you didn't. Costanza's going to come back and say, no, it's okay to do this part. So you just want to make sure that the mechanic you use as your expert is reputable, has experience, because it's going to be somewhat of a swearing match for the fact finder to determine who to believe, Costanza or Putty. And go ahead.
I was just going to say that these cases are really difficult for low-income clients because these experts are going to want to get paid, especially if you're talking about an expert from North Carolina. And when I get cases like this, a lot of times I just realize that there's no resources available for us to have that argument in court. So you've got to find something else. And John alluded to in the beginning, a lot of times the client comes to you with this story, and you look at it and you go like, there's no way I'm going to be able to prove this stuff. That's when you get the documents out. You start digging through the documents. A lot of times the client comes in and says, I just want my car fixed. And you realize there's been a fraud or some violation of the statute in the contract of sale. And with that, or a fraud in the sale. And with that, you can put leverage on one side or the other to resolve the issue without getting to the sale.
Yeah, and it's going to make you improve your negotiation skills, right? Because let's say it's only $1,000 to fix this problem. Your expert mechanic's going to charge you $500 to show up to court. You don't get that under negligence. You don't get repaid for your expert fees. So you're basically going to net $500 if you're successful. But if in the contract, the service contract, or the repair order, or whatever with this company has an arbitration clause, as John said, that's leverage. You can say, you can spend $3,000 to $5,000 initiating arbitration, or you can just pay my guy the $1,000 to fix it. Once again, you just need to find something, as Steve keeps alluding to, that something to give you leverage to make these people these dealerships and mechanics realize the cost-benefit analysis of just being done with it now. Because even if you file that warrant in debt or that complaint, they're going to have to hire an attorney to represent them, right? They're an entity. They can't represent themselves. That's money they have to spend. So if you can put that in the demand letter, if you can get that across to them in the phone call and say, hey, you're looking at the next $4,000 to $6,000 in legal fees just on your side, whatever. Plus, you may have to pay our fees because of the VCPA violation, blah, blah, blah. Let's just be done with this for this time. So the more little potential claims and violations you can find, you can use that to your advantage to hopefully get these things settled pretty quickly.
Ian, I've got a question for you because some people in the room who don't have litigation backgrounds might be thinking, boy, I'm hearing a lot about trials and lawsuits and argument before the judge. In these cases that we're talking about today, generalizing, how often can it be resolved through a letter writing campaign versus having to file a complaint, show up in court?
So John he'll tell you his side. He's got more experience different than me. My experience with the letter campaign is probably 50-50. Some of these dealerships realize they messed up and they understand the cost-benefit analysis because they probably got hammered before and they had to pay a lot of legal fees. So they realize, let's just be done with this now. Whereas you might get a dealership who's pretty arrogant. One of the buy here, pay here places don't think they did anything wrong. They might fight you all the way through it. So to me, a demand letter, in my experience, works half the time of just settling it pretty quick in probably an hour to 2 hours worth of time of sending a demand letter, calling the dealership, talking to them. Whereas the other side of the coin is you're going to be going through GDC. And GDC is pretty quick. You get in your case, within 45, 60 days. You get a trial scheduled in 2 to 4 months. So this could be done in 6 months. And there's not too many motions or anything in general district court. I mean, you have the $25,000 limit. So most of these legal aid clients' cases with their diminished value, even if you treble that under the Virginia Consumer Protection Act for an intentional violation, will still fall under that $25,000. So these things can maybe be done with trial in 4 to 6 months and take, 10 hours of your time or something.
Let me, I'm going to jump around a second. I want you all to pull out this credit contract or the retail installment sales contract. And I want you to turn to the next to last page. And you'll see in the left-hand column, about 3/4 of the way down, something that says notices. This is the FTC holder rule. And let's read it. Now, who's holding this note? This is a note or an IOU that your client has signed and given to the dealer, and the dealer has assigned this note to the lender. In this case, it should say somewhere. Did you? Okay. Well, the initial creditor is almost always the dealer, and then the third-party lender who the dealer got the loan through, who sold this loan, and who's holding this paper. This is the contract that GE Financial or one of the big lending companies may have, Lendmark or whoever, has got it. And what does it say? This consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller or services obtained pursuant hereto or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed the amounts paid by the debtor hereunder. That's incredibly important. The FTC holder rule, what it means is that lender is liable for any of the violations of law that the seller did. So when your client comes in with a repossessed car or worried about a repossession, or maybe it hadn't been repossessed yet, he's just, I can't make my note payments and I don't know what to do. You can, this clause means that the lender is liable because of the seller's fraud or the seller's Virginia Consumer Protection Act violations or the seller's negligence or whatever, if this clause would apply, and therefore they're liable for it. And this is why when we get a case in and there's a repo, we will use the arbitration clause against the lender, who's a big bucks, who goes, screw this, let's just charge this off. And Gail will pay you a couple of fees or will allege fraud, and they don't want to deal with the arbitration because they are liable for the dealer's misrepresentations. Does everybody understand that? Because it's a very good piece of leverage against the lender itself. And you can say, look, Mr. Lender, just let him out of the contract. Oftentimes there's a recourse clause that they can force the seller to buy back the loan. There's a non-recourse loan and there's a recourse loan. Explain that. A lender can buy a contract from a dealer on a non-recourse loan, which means that if the buyer defaults, there's no recourse. He can only go against the buyer. The lender can't go against the seller. A recourse loan means the lender can say to the seller, I don't want this deal anymore. It's a recourse deal, and you're buying it back. Most of the smaller amounts of money are done on recourse. The larger lenders will do non-recourse with the larger dealerships. So I wanted you to see that, and I'd like you to then turn back to the page 18 of Ian's outline and my outline on page 18. I'm afraid we weren't going to get to this. I want to leave some time for questions if possible, if we have any. Page 18 talks about the Motor Vehicle Transaction Recovery Fund. So your client comes in and you've got a good case for fraud against this mom and pop dealership, and you get a judgment for fraud against the dealership, which often happens, and they go, fine, I'm ready to business. And they just close up the shop. And you're stuck holding what do we say in law school, a turnip that you can't get any blood out of that car dealer. And the Transaction Recovery Fund is there for any dealer that you get a judgment for fraud. You can get up to $25,000 for your judgment that will cover your client's actual damages and any legal fees. So it's important to know that. And on top of this, if the dealer is a relatively new car dealer, the DMV requires them to have insurance, and it's called a bond. And so you can go after the bond on this car dealership for recovery of your judgment obtained that you obtained for fraud. But remember, don't make the mistake I did the first time I did this. I got to court suing under fraud, suing under the Consumer Protection Act, great case, and the dealership didn't show up. Judge goes, Mr. Gale, there's no one here on the return date. I go, I'd like judgment, Your Honor. He goes, default judgment. I don't have to go worry about the dealer because I don't care whether he's in business or not. I'm just going after the fund. The fund says, Mr. Gale, where's your judgment for fraud? Well, I don't have a judgment for fraud. I've got a default judgment and alleged fraud. You don't have a judgment for fraud. So what you have to do, trust me, is you have to, if the dealership fails to show, you set a hearing date and have your client come in and bring them in to describe the fraud so the judge can give you a judgment based on the evidence. Your judgment's not for fraud. It's just a default judgment. And it's a judgment, but it's not necessarily for fraud. However, if you put on the evidence and you convince the judge that there was actual fraud, and there'll be no one on the other side calling your client a liar, and he'll give you or she will give you a judgment for fraud, you make sure your order or the warrant and debt says judgment for actual fraud. And if he gives you legal fees, you put your legal fees on, and they'll give you your legal fees. And then you can go after this Transaction Recovery Fund and tell them what happened. You show them your order. You verify that you didn't just make these numbers up. The dealer board will want some verification. Unfortunately, they will go behind the judge and go, well, how did you prove $10,000 in damages to this judge? And you go, well, a loss of use, and you show some receipts, and you can verify that the actual damages was whatever your judgment gave you. You show them your legal fees, and you will get your money from the dealer board. I just thought that was helpful for you all to know. We have not talked about breach of warranty very much, and let's talk about that a second. People will come to you and go, I've got this car and I've got a warranty and there's no fraud involved, but they just can't seem to fix it. And I've brought it in 3 times, 4 times, 5 times, and it doesn't. The Virginia lemon law doesn't apply. The lemon law has a limited time period of 18 months from delivery, so we don't want to that may or may not be applicable. Most of your people will not have a new car or a recently used car. You will have older vehicles. That does not mean you don't have a claim. You've got a claim possibly for breach of warranty because your client bought that car on a promise. The promise was, the warrantor says, this is not a service contract necessarily, because we're going against the dealer. The service contracts they're not the dealer. So the warrantor, you need to have a written warranty. It helps to have a written warranty. And if you've got a written warranty from the dealer, they've promised to fix your client's car if any problems occur. If they don't fix it within a reasonable number of times, they've breached the warranty. They will defend and say, our warranty says we will repair or replace a defective part. And we are continually willing to do that. But the case law has interpreted warranties that say that these warranties fail of their effective purpose if you can't fix the car within a reasonable number of repair attempts. So what's a reasonable number of repair attempts? That's why we wrote the lemon law, because we define it under the lemon law as 3 times or 30 days in the shop or 1 time for a life-threatening safety-related defect. But under a standard breach of warranty, which is going to apply to most of your clients who have written warranties, has the dealership or the warrantor failed to repair the vehicle within a reasonable number of times? What number is that? 3? The lemon law says 3. And 1 or 30 days in the shop, but that wouldn't apply. So you've just got to convince the fact finder that your client has brought it in out 3 times for the same problem. It needs to be a significant problem. And if you can convince them of that, you're entitled to your damages, which would be that same amount of money, which would be the diminished value, the amount of the real value of the car in the date of sale if the truth were known that they weren't going to be able to fix this. There is a second remedy that we all should know about called revocation of acceptance. Many of your clients will say, well, I don't even want the car because damages, that diminished value that you're entitled to, means they keep the car. They may get $3,000 or $4,000 or whatever the diminished value was between what the car was worth and what it sold for, but they still have this hunk of junk that they don't want. And they're still making monthly payments on it. So they're going to go, I don't want the car. I just want to get out of it. Well, there is a remedy called revocation of acceptance, which is 8.2-608 of the UCC. It's Virginia's numbers. And revocation of acceptance is that if that vehicle is substantially impaired in value to the buyer, then you're entitled to revoke your acceptance and get all your money back. Huge caveat. They cannot keep driving the car. And that's why we wrote the lemon law. Because the stupid 1978 Virginia Supreme Court said, well, you've got to keep driving the car. You can't keep driving the car. You have to stop driving it and give the seller notice of the problem in writing. It would be helpful. And then you say, I'm going to stop, give me my money back, or I'm going to revoke my acceptance. They don't give you money back. You say, okay, you revoke your acceptance. I'm hereby revoking my acceptance, and you stop driving the car, and you sue them for essentially cancellation of the contract and all your money back. There's no legal fees. The Magnuson-Moss Warranty Act gives you legal fees. UCC doesn't. Magnuson-Moss Warranty Act says it applies to legal and equitable remedies. Revocation of acceptance is an equitable remedy. Don't you all remember your equity class in law school? I know you remember everything. But anyway, that is another remedy for you if they really don't want the car. But if they have to keep driving it, which most people will because they have a loan on it. They can't stop driving a car and have a loan on it. They can't stop making the loan payments. Except for one section called 8.2-717 of the UCC, which says that you may, if there's a dispute, you can stop making your loan payments to the seller to cover your damages up until your damages are paid for in a dispute. 8.2-717. That would also apply to a fraud claim under 8.2-721. Because any breach of contract remedy under the UCC is also applicable to a fraud claim. But the practical side of this is, okay, Mr. Gale, are you telling me that I can stop making my loan payments if I write the lender and tell him I'm going to do so under 717? Yes, you can. And then what happens? I would always write the lender and say, we're going to stop our loan payments under 717. We would like your agreement to do so. If they refuse, I've had them say, okay, during the course of this litigation, we'll let you stop. Most of them refuse to. So then the smart thing to do, and I know you don't want to go through all this stuff, but maybe you could. I'm doing it in some cases. Filing a motion for temporary injunction. Once I file the lawsuit, you go to the judge with your complaint or your warrant debt. You file a motion for temporary injunction to order the lender to not take any adverse action against your client based on your ability under 717 to stop making payments. Because if you just stop making payments, they're going to repossess the car. You're going to lose your evidence to prove your case, and your client's going to have credit hits stuff on his credit that's going to screw him up. Yes, you might have a claim against the lender for the damages from that later on, but I just tell people to go on and make the payments if they can afford it, or let me go through this process of notifying the lender, we're going to stop making our payments, will you agree? When they don't agree, we file for a temporary injunction so that your poor client doesn't have to make payments on a car that's not working, and it gives you the right to keep going forward in the litigation. That's about all I got. Let me just look at.
While he's looking, I'll just say that a lot of times what happens to car clients, what's going to happen to bit with these cases is that Marty or myself will screen them, identify some of the major issues, put together the paperwork, and that's how you'll get it, with some of these issues identified. And you still have to sit down with the client and do all the work. The most likely case that comes before us is the client bought a bad car, started making payments, then the car breaks, they go through some negotiation with the dealer to try to fix it. The dealer either tells them, hey, there's no warranty or a service contract, that's who you got to deal with, I'm not dealing with it. And then the client says, well, I'm not continuing to pay for a car that's not working, and stops paying for it. And then the bank comes and repos it. Then the client comes to see you. And so now you're going back and looking at a lot of the issues we have from the position where the car has been repoed. And so there may be a finance problem, there might be a sales problem, there might be a warranty problem, there might be all three. And you're going to be from that position trying to get either the car back or the money back for the client. Those are tough. The only other thing, and this is something we didn't touch on, and we can get into another whole hour about financing. But a big trick that a lot of dealers have is some sort of bait and switch or yo-yo sale. And a lot of times you get clients that come in with that. My most recent car case had a client and said that she had bought a car, had taken it home, and what the dealer's trying to do here is they got a hot buyer in the dealership. They want to close the deal. The dealer doesn't want to have the note. They don't want to have this loan. They don't want to finance it. They want to sell the note. But they'll get the client to sell the customer to sign any deal they can. Then the customer goes away. And then either the dealer knowingly decides, you know what, I bet I can get him back in here and sign a deal that's better for me on the note. Or they try to sell the note and nobody wants to buy it because our clients are big credit risks. And so they're going to ask for a higher interest rate or more down payment or something like that. And so the customer who's driving around the car for a couple of weeks gets a call from the dealer and says, oh, your financing fell through, you got to come back in. And a lot of times they go like, oh, I want to keep this car, I need to get to work, I like it, I got my stickers in it now. And so they go back and they sign this new deal. I had a client who came to me because after 4 times of going back and signing 4 different deals, the dealer still hadn't sent the title to her. She couldn't register it. The 30-day plates had long expired, and now she had gotten a ticket for driving with expired plates, and she couldn't drive the car anymore. And so I sued them for fraud on the contract because they had signed these contracts saying that they were going to be the financer on all these deals. They were expecting to send it off to somebody. They had signed all these buyer's orders. This is America, right? When you sign a contract, don't you expect to be able to enforce it at some point? She had 4 of them. So she lost the car in the end, but they paid her enough to buy a new car. I don't think there's much better for our clients than getting a new car out of this bad deal.
There is a statute that says if they don't give your client title within, I think it's 46.2-1530, that says that when you buy a car, what do you expect to get? Not just the car, you expect to get the title, right? But if you're financing it, who gets the title? Well, the lender gets the title. But you get a permanent registration. And that registration will have a title number on it because they've gone to the dealership, they've gone to DMV and applied for title in your name, and a title has been issued with the lien holder name on it and your name on it, and the lien holder's got it. That's the way it's supposed to work. But when they don't give you title, in other words, you've got a 30-day tag, right? And your tags are about to run out, and you call the dealer up, and he goes, well, I don't have your title yet. I can't give you, come on in, I'll give you a second set of tags. Well, what's going on is that the dealer has bought that car, but never paid for it. So the seller to the dealer is not giving him title. With me? He's bought the car at an auction. He said, oh, great, I'll send you the money in 3 days. And the seller goes, okay, fine, I'll send you the title when you send me the money. And the dealer never gives him the money because he doesn't have it. He's paying Peter and Paul and all that. So he doesn't have the title. But then he sold it to your client without ever having had title in his hands.
Which is a fraud to begin with.
Which are violations. But so this is where it gets complicated. So let me just say that this is how this happens. So that 30 days goes by and he doesn't have it. He says, come on in, I'll give you a second set of tags. The statute says that in order to get a second set of tags, you've got to apply to DMV for the title after the 30 days and explain why you don't have the title yet. But you apply, and then they'll let you issue a second set of temporary tags. So you're on a second set of temporary tags. There's a statute that says that if the dealer, I think it's 1546.2-1530, that says that if the dealership fails to give you title in 30 days, then you're entitled for all your money back, less the miles that you put on it at the limit law rate. So that's important. That's some leverage right there. And I also think it's important, Steve was talking about yo-yo sales. Look on page 13 of this outline. We go into pretty decent detail about what's involved in a yo-yo sale. Page 13 of the outline. Dealers will call it spot delivery. We call it yo-yo because it's they give you the car and they yank it back, right? And that's just an explanation of what's going on. And I wanted now, just having showed you that, let's look at the second page of the buyer's order. Pull out this document, the buyer's order. Okay, look on the back, or what is the second page, and you'll see this language in all caps, which is a tactic that I've seen dealers do because you can't understand all caps. It's almost like you lose your train of thought. But in any case, there it is. And it's the law. It's what's required by the law. And it says, if you're financing this vehicle, please close below. You are proposing to enter into a retail installment sales contract, which is the credit contract, to purchase the vehicle. If you're financing the vehicle and the dealer intends to transfer your financing to what we really would call a third party, to a finance provider such as a bank, credit union, or other lender, your purchase depends on that finance provider's approval of your retail installment sales contract. Now stop. Put your finger there. The dealer has come in at that point and said, you're approved. The dealer has not said, we hope you're going to get approved, and here's your car, and go drive it, and when your vehicle gets approved, we'll let you know. He's told you you're approved, which is fraud, if you haven't been. So you'd believe you've been approved. But anyway, if your retail installments contract is approved without a change that increases the cost or risk to the dealer, then your purchase cannot be canceled. In other words, when he goes and tries to sell this loan and the buyer, the lender's third-party lender says, okay, I'll take it, pay you the money, then you can't get out of it. But it says if your retail contract is not approved, the dealer will notify you in writing or verbally, and then you can decide whether to pay for the vehicle in some other way. In other words, you can get a loan from mom or dad or whoever, or you or the dealer can cancel your purchase. Let's put your finger there. So what happens is the dealer calls you up after 3 weeks who has intentionally done this. He may have intentionally lied to you about your being approved because he wants you to be emotionally committed to that car. He wants you to have shown all your friends and family so that you'll be incredibly embarrassed if you have to give it up because your credit got turned down. And then he's going to call you back in 3 weeks and say, come on in and we're going to be blown to get approved and try to get you to sign a worse contract. And these people will because they just need their wheels. They need to get to work. They're embarrassed. They want that car, whatever. But what does this say? It gives you the right to cancel it. So when they call you in and say, hey, your loan's going to get approved, you can say, fine. Okay, here's your car. If the sale is canceled, you need to return the vehicle within 24 hours of verbal or written notice in the same condition, wear and tear accepted, and any down payment or trade-in you gave to the dealer will be returned to you. Stop. So when you take that car back and he says your loan wasn't approved and we're going to bring the car back in, you need to tell your client, go in there. They've called me up and they've told me I got to bring this car back and I don't want to. I mean, I thought I was approved. Go in with somebody so there can be a witness and have them listen and say, all right, here's your car. Give me my down payment back and my trade-in, or one or the other. Not your trade-in and some money taken out for all the miles you put on the car they gave you, but your entire down payment, because that's what it says, and your trade-in. And if they don't, if you continue to read this, it's a violation of the Virginia Consumer Protection Act.
And John, let me ask you this. How often does the dealer still have the trade-in on their lot and give it right back to you?
Well, then that brings up the question of, well, if he doesn't have the trade-in, how much money are they going to give you for the trade-in? And the dealer, if they're semi-smart, but not super smart, will say, all right, I can't give you your trade-in back, but according to our buyer's order, your trade-in was worth gross trade $16,920, so we're going to give you $16,920. But was that what your vehicle was worth? No. Your vehicle is worth the retail value, not the trade-in value. Follow me? So that even if they go, but Marty's right. They don't have your trade-in because what they'll do is say, oh, we sold your trade-in, we don't have it, but thank you for the car. See you later. We'll get you back. Well, how am I supposed to get home? I mean, they keep people. Nowadays, I guess we have Uber, but people were stuck at the dealership because went and signed another contract, they will tell me, because I didn't have any other way to get home. So I said, what the hell, I'll sign a worse contract. Ian and I have different opinions on this. I don't think it's worth taking these cases if they don't take the trade-in or your down payment. If they don't give it back to you in full, because you've got to clear up. Ian, and I respect Ian, and maybe he's going to have some success with this possibly, and you all could. And Ian, I want you to explain why, even if they give you back your trade-in and all your down payment, and you have no actual damages for that, why do you think it's worth taking these cases?
Well, it's still a misrepresentation, right? On the date of sale, they told you, you're approved, here's your new Corolla, whatever, when in fact you never were approved. So despite them calling you and say, hey, financing was not approved, bring it back, and you get your down payment back, I believe you're still entitled to your damages under the VCPA and possibly treble that. So it's not just, oh, your down payment of $2,000 is returned to you, have a good day. No, I want $6,000 because y'all lied to me on purpose on the date of sale. You shouldn't just get a slap on the wrist and go back to zero how you were. I think you should have to pay possibly treble damages and my attorney's fees. And maybe they won't do this again to somebody else.
I think that's a risky way because for me, I don't want to go in there and spend 6 hours at $450 an hour and say no. But you can do this because you're not trying to get paid.
I know we're at the end of our time. I just wanted to add, and this thing I think that makes these cases fun, is that the fact scenarios are always just slightly different, and yet there's so much great law out there, federal and state, like I said at the beginning, that you know on. Quick war story, I had a client who got involved with a yo-yo sale, just refused to go back in. Now he says, I signed a contract, I signed a loan. This is America. I'm going to make you enforce it. So they came and repoed the car. There's rules on what you do with a repo. Notices you have to send out. A sale that has to happen. But the dealer didn't see it as a repossession in the classic sense that they had defaulted on a loan because the guy was paying on the loan. He was ready to pay. They saw it as, you never had a loan and we're just going to come and get our car back. I took him to court over a faulty repo. And the damages, you don't have to, because I can't remember all this, but the damages on that, I think 10% of the sales price plus what's it?
Finance charge.
Plus the finance charge. Well, for our clients, they're paying like 25, 35, 40% interest. The finance charge is huge. So it's 10% of the sales price, but sometimes the finance charge is more than, well, that's the interest of the total loan, is more than what they paid for the car. Because most of these dealers aren't selling cars. They don't make any money off the cars. They make money off the financing. So even the judge was shocked at the amount of damages I could get for a bad repossession. And that's a really easy one to prove. Did you send this notice? No? There you go. It's wrong under the UCC and Virginia law. And here's the statutory damage.
It's 8.2-625. And if you pull out this retail installment sales contract, sorry to make y'all do this, but just so you understand, it's a statutory limit. So even if your client doesn't have any damages, if the dealer, like Steve said, has violated the law and there's been an unlawful repo when there's been no default, what he's saying is you're not in default. They came and come and taken your car. So what are you entitled to? Under 625, 8.2-625, you're entitled to the amount financed plus 10% of the finance charge. So you're entitled to $5,200 plus 10% of the finance charge, or maybe it's the reverse. I can't remember. But that in this case, we're talking $7,500 in statutory damages, which is a lot of money to your client.
And this can be used, just one more thing, like I've always been mentioning about the leverage to try to get these dealerships to settle. Even if you get the case where the person bought a car, it craps out on them, they're like, why am I going to pay for a car that I can't even drive? They're over 10 days late, so they get repoed. But the UCC unlawful repossession violation comes in when the sketchy tow company breaches the peace, right? It's in the middle of the night. Your client is saying, she or he are in the pajamas. They're saying, don't take my car. And they still continue to take the car. That's a breach of the peace. That's a violation of the statute. You get finance charge plus 10%. So make sure your client tells you everything that happened during repossession. Oh, he took the tow guy took the keys out of my hand. There's like that show about the tow company. So these tow guys enjoy being abrasive, some of these companies. So you might be able to get that UCC remedy if they breach the peace.
And two big commercials. Commercial number one is about the National Consumer Law Center. You can see this automobile fraud manual. It is updated regularly. It is massively useful, and it is one of only 20 volumes that the National Consumer Law Center puts out on all aspects of consumer law, including consumer warranty law, repossessions, and of course automobile fraud. So that's commercial one.
We have a full set, too. So
We have a
if you
whole
need
set.
them.
Commercial two is how do you get these cases? Well, it's basically a two-step process. If you're interested and want to be part of a team, tell the team leaders, Ryan Fry or Neil Kessler, that you want on their team. What Steve and I will do is we will send cases to Ryan and Neil to shop amongst the team members. And if you want a case, then hopefully you've done step 2, which is you registered in Justice Server, www.justiceserver.org. It's the new Justice Server 2.0. It takes 5 minutes to register, and you really, all you have to do is indicate the legal aid programs that you want cases from. Hopefully you'll indicate Central Virginia Legal Aid Society. Once you're registered, and once we hear from either Neil or Ryan that you want a case, the new Justice Server 2.0 allows us to directly assign the case to you. You'll get an email that says, hey, this case has been assigned to you. Follow the link. Follow the link, you accept it. You get to check conflicts of interest before you accept it. You accept it, the case is yours. Nobody else has ever seen it. You have complete access to our information, all of the client information, all of our notes, all of our documents. You can upload and download everything. It's complete two-way communication between us and you, and it's your case to work on. In fact, you can even keep time on the case on Justice Server 2.0 if you want to. So it's a vast improvement over to the old system, and we hope you'll register and use it.
To me, just listening to this seems like a really great area for partnership. And I don't know how many of you are litigators versus transactional attorneys, but Justice Server allows for more than one attorney to work on the same case. And it's partner in that way. It's really fantastic. It's somebody who's really into the contract reading, and somebody else is the one that wants to get the court. It's a really great place for
So your partner can register in Justice Server. Then you tell Steve or I, hey, add this person to the case. I pull them up, assign, and then again they get the email link. They accept, they follow the link, they check conflicts, they accept the case, and now 2 people have full access to the case, et cetera, et cetera.
And you all, please, I'm sure Steve and Marty feel the same way. I know Ian does. Call me. Call Ian, call Marty, call Steve. You want to write down my number, it's 804-282-7900. It's the same for Ian. If you've got any questions, hey, John, give me run this by you, and I'd love to help you because our goal is to help people as yours is. And we don't want bad law to be made by y'all screwing it up.
Thank you guys very, very much.